Welcome. My name is Michael Frumkin, and I'm the organizer of this University of Miami Law School seminar series on the constitutional crisis. Our topic today is control of the executive branch, and our speaker is Thomas Berry, who's the director of the Cato Institute's Robert A. Levy Center for Constitutional Studies and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was an attorney at the Pacific Legal Foundation and clerk for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. Mr. Berry has had an interesting legal career, one small part of which got a lot of notice was he helped author an amicus brief in a case involving whether disparaging terms can be trademarked. George Will called that brief amusing. It was a case concerned whether the name of an Asian American rock band, the Slants, I liked them, could be trademarked. Berry's team titled its submission, Brief of the Cato Institute in a Basket of Deplorable People and Organizations, which has to be one of the best titles for an amicus brief I've ever read. In that case, the Supreme Court, per Justice Alito, liberalized trademark registration law, holding that the disparagement exception in the Lanham Act was facially unconstitutional. More to the point here, Mr. Berry's academic work has appeared in the NYU Journal of Law and Liberty, Washington Emily Law Review Online, the Federalist Society Review. His popular writing has appeared in the Wall Street Journal, the National Law Journal, Investors Business Daily, National Review Online, and The Hill Online. He's testified before the Senate, and his work has been cited by the District Court for the District of Columbia. He holds a JD from the Stanford Law School, where he was senior editor on the Stanford Law and Policy Review, and a Bradley Student Fellow in the Stanford Constitutional Law Center. He graduated with a BA in liberal arts from St. John's College in Santa Fe. During law school, Mr. Berry entered at both Cato and one of my favorites, the Institute for Justice, a public interest law firm in Arlington, Virginia. And by the way, I recommend their newsletter. It's great. Mr. Berry is widely acknowledged as a leading authority on the Vacancies Act, which will be the focus, but I think not the sole focus, of his talk today. We are very grateful to Mr. Berry for taking the time from his busy brief writing and other schedule to speak to us. I'm going to put myself on mute and turn it over to you. Go ahead, please.
All right. Well, thanks so much. I'm honored to be invited. Just looking at the list of other speakers, it's a real honor to be in any list included with them. And I saw you had my colleague Ilya Selman earlier this team. He's our, among other things, he's our B. Kenneth Simon Chair in Constitutional Thought. And so I love working with Ilya on many of these issues. So as mentioned, I'm going to talk about appointments, removals, Vacancies Act, and some other related controversies. I think just to set the framework, one thing I want you to keep in mind as I start is that the question of how much unilateral presidential control there should be or there is under the Constitution might well be different. And I think it is different for those two categories, appointments and removals. I often see people sort of conflate the two or assume that the answer is the same for the two. So, for example, the Supreme Court clearly seems to be moving in a direction more in favor of unilateral presidential authority over removals. And I've seen many commentators kind of jump to the conclusion that that means they similarly would be sympathetic to unilateral presidential authority over appointments. And I don't think that's necessarily true or should be true for the reasons that I'll get into, but the main one simply being textual from the Constitution, that the Constitution explicitly gives a role to the Senate, a body outside the executive branch, for appointments in a way that it doesn't explicitly give a role outside the executive branch for removals. So I'm going to start with appointments and then move on to removals. So at the Constitutional Convention, there was a lot of debate about what's the best method for appointing all of the people who would fill out the executive branch underneath the president. The Constitution doesn't set out or describe any of the offices within the executive branch besides the president and vice president. That was all for Congress to create those offices and to then be filled and stocked from one administration to the next. And there are a few competing theories at the Constitutional Convention about what would be the best method. Some people said that just the president alone made the most sense to appoint all of them for a few reasons. One of them being the president is the boss of the executive branch, so they assumed the president would have the best knowledge of what's most needed for each individual position. He would be the boss of those people themselves. And it usually makes sense that if you're going to be someone's boss, you would want to have the main role in picking those people. But there was concern raised by several members of the Constitutional Convention in a few directions. One was simply the threat of cronyism and nepotism. That's a lot of power to put in just one person's hands. Especially if you go back to think about early America, there wasn't sort of as much nationwide communication as we have now. It wasn't as easy to know who's the really smart person in Georgia if you're from Massachusetts or vice versa. So there was an assumption that a president from Massachusetts is just going to pick all of his friends that he knew or grew up with or worked with in Massachusetts. And that might not be the best for the functioning of the country overall. And it might just be he favors his friends over the people who are actually more qualified. So there was a competing group at the Constitutional Convention that said, no, the executive branch should be stocked from people all over the country, and the body that knows the whole country most evenly is the Senate, 2 senators from each state. They should be the one that should put their heads together and collectively pick all of the office holders. And then you would likely get a good mix of people from all across the country. And they would likely focus on talent rather than friendship, because no one single senator would have the sway to just pick his own friends or his own, cronies, nepotism, etc. But there was a critique of that role as well, which is, how hard is it to make a decision by committee? We've seen how hard is it even for the Senate to agree on legislation, let alone on picking, at the time, dozens, now thousands of people to stock the executive branch. So as with so many things, the framers compromised and tried to get the best of both worlds, or the best of both proposals. So they came up with this hybrid system where the president would nominate people to serve in the executive branch, but they wouldn't actually be appointed. And appointed is the term for actually being installed in office until the Senate gave its advice and consent to that nomination. So essentially a majority vote in the Senate approving officers of the United States to serve in those offices. So Gouverneur Morris, one of the influential members of the Constitutional Convention, described this hybrid system, saying as the president was to appoint, there would be accountability, meaning one person you can blame for a bad nomination. But as the Senate was to confirm, there would be security, meaning that if the president went rogue and picked an unqualified crony, the Senate would vote him down. Alexander Hamilton wrote about this system as well in Federalist 75 and 76. And he predicted that the Senate would rarely have to actually vote people down, because just the fear of that happening, the embarrassment of that potentially happening, would cause the president to avoid any potentially shady characters. I believe the exact language he used is it would do much to prevent the appointment of unfit characters to the federal government. And you can query whether that has been successful or not, or whether it has worked as planned. But that was at least the idea, that Senate confirmation would be an important check. But in addition to that default system, on the very last day of the Constitutional Convention, the kind of nitpicking, last minute cram, oh, did we forget XYZ day? Someone said, wait, we should put in a clause for inferior officers because it might be too cumbersome to have the Senate have to confirm every single inferior officer of the United States. Unfortunately, for us as modern interpreters, nobody said what they meant by inferior officers. So that's something that we have to deal with now. And there's not a lot of hard evidence from that era of what did they mean by inferior officers, but that's the term that they used. So someone proposed language saying that Congress, if it wanted, could point out a particular inferior office and say that instead of Senate confirmation, it can just be filled by the president unilaterally, the president alone without Senate confirmation, or by a head of a department alone, or by a court of law alone. So in all 3 instances, cutting out that Senate confirmation step. Originally, they voted on it once, and it was a split, which means it wasn't approved. And then someone said, no, we need to have something like this. So they voted a second time, and it was approved unanimously. And that's literally all we have from Madison's notes on the convention on what has turned out to be an extremely consequential clause of the Appointments Clause, the Inferior Officer Clause. If we didn't have the Inferior Officer Clause, every single person exercising authority under the laws of the United States would need to be confirmed by the Senate. And so you'd have even more of a bottleneck than you already do. Congress, they also at some point realize, wait, there's another concern. What if the Secretary of War dies when the Senate is not in the Capitol? And at the time, again, that was a much more likely possibility. It was not a 24/7, 365 Congress. They would go home. Travel took a long time, so they typically were only in the Capitol for a few months out of the year. And so it could take quite a long time for them to come back to the Capitol. And in general, they wouldn't come back just for an emergency. But you can imagine it might be a serious hindrance to the operations of the federal government if, an important cabinet member dies and you don't have anyone to fulfill their role, maybe for months at a time. So they put in the recess appointments clause, which says that if a vacancy shall happen during the recess of the Senate, the president can appoint someone without Senate confirmation, but only to serve in that position until the end of the next Congress. So basically, up until the Senate has come back and had a full session to consider a full-time nominee. But they didn't put in anything in the Constitution about, okay, what if someone unexpectedly dies or resigns while the Senate is still in session? Obviously, the Senate could move quickly, but that doesn't mean they're going to. And for some positions, you might say even a week or even, a few days could be a real problem if you have no one in that position. If the Secretary of War dies in the middle of a war, and the Senate, could take a few days to consider someone or might disagree with the president's first choice. So how do we think about that silence? What is permissible? What role can Congress create? What systems can Congress create to gap fill in that scenario where there's an unexpected vacancy, but the president can't use the recess appointments clause? In the first sometime during George Washington's presidency, I think second Congress, so the latter half of his first term, Congress passes kind of the first version of a Proto-Vacancies Act that says that if there is a vacancy in one of the three main cabinet members, which at the time were just State, War, and Treasury, then their chief clerk would temporarily perform their duties. And I believe it said that this would happen if they died or resigned or were sick or were simply traveling outside the Capitol, which again, we don't think that that's an issue today with instant internet communication. But at the time, if someone's traveling outside the Capitol, they're basically incommunicado. They can't make immediate decisions if there's some sort of crisis back at the Capitol. So interestingly, it didn't describe these chief clerks as taking the actual job. It just said that they would perform the duties of the job for a limited time. And important to stress that at the time, chief clerks were treated as inferior officers. They were specifically called that in the statutes creating them. And they were the first example where Congress said these people don't need to be confirmed by the Senate. So they were basically assistants to, handling logistics of the department, but not necessarily making the consequential decisions, except when there might have been a vacancy or a short-term illness or something like that. Fast forward, so originally there was no time limit whatsoever. Just 2 years later, Congress revises that statute and they add a 6-month time limit to that service. So perhaps they thought, oh, this could be a loophole that can be exploited if we don't put any kind of time limit on this service. Congress, over the next century, revises the Vacancies Act several times again. It lowers the time limit dramatically at one point to as short as 10 days. Then it ups it to about 30 days. And then to about 120 days. It also shifts who's eligible. So in addition to the chief clerk, it broadens it to apply to essentially any position the Vacancies Act could apply to. And it says whatever their assistant is, their first assistant. So not just if a cabinet member is vacant, but if any member of the federal government is vacant who normally requires Senate consent, you would have whoever is the first in line below them or anyone else who has been Senate confirmed across the government could instead be picked if the president doesn't want their chief clerk or their first assistant to be filling in for them. So that was the state of affairs for about a century. And then the most recent version of the Vacancies Act was passed in 1998. It was called the Federal Vacancies Reform Act. And as the word reform in there suggests, it was an attempt to tighten what had been seen as some loopholes or some possibilities for abuse that had developed over the course of the decades in the Vacancies Act. So it was a push and pull compromise because, of course, anytime you pass a new statute, you need the president to sign it. And the president is going to be loath to sign a statute that limits his discretion for who he can pick as actings or for how long. So it was kind of a compromise where it limited the president in some respects, but gave the president more options in other respects. So the two key reforms in the FVRA, as it's called, that's the acronym of 1998, where it put in explicitly that if someone is illegally serving as an acting, so their time limit ran out or they weren't actually eligible to be an acting, but the president appointed them as an acting anyway, and they perform an exclusive duty of the office they're purporting to hold, but actually hold illegally, then you can sue. Anyone who's affected by that can go to court, sue, get it struck down. So there's a real stick aspect to it. It's like if the executive branch wants its actions to be upheld and not be subject to court, invalidation, they want to make sure they're not cutting corners and that they're actually following the limits of the Vacancies Act. And then a second key provision said that the president, that it's the exclusive means of allowing someone to temporarily perform the functions and duties of an office, and that any statute related to subdelegating powers is not an alternative to make someone an acting officer. So why did Congress think it was so important to put that in? Because this is essentially what had developed as the key loophole or the key end run around the Vacancies Act and its time limits or its eligibility requirements. What had happened starting around the 70s with President Nixon and then going through pretty much all the presidents after him through Bill Clinton is that if a time limit ran out on an acting, or if someone just wasn't eligible to be an acting because they weren't the first assistant or they weren't Senate confirmed in some other job, they would say, oh, we're not appointing them under the Vacancies Act. We're just appointing them to the civil service in general, to some low-ranking position, and then subdelegating them all the powers that that office would have had. So essentially, they become the acting officer in all but name, via subdelegation rather than the Vacancies Act. And the reason that that was a plausible end run around the Vacancies Act is that powers are extremely malleable, extremely flexible within all of the departments, going back to essentially the Truman-Eisenhower era. There was a reform movement during that time that said, there's too much sort of bottlenecks in the executive branch. There's too many complicated rules about who can do what. We need to just focus on efficiency and let the executive branch decide what's the most efficient way to let people do different tasks. So we're just going to rewrite all these statutes in a really simple way and say that every power of an entire department is vested in its cabinet head. And then that cabinet head may choose, whenever he or she wishes, to subdelegate any of those powers to anybody. So this sort of goes against what we think of as the way offices are set up, and certainly the way the framers would have thought of offices as being set up, which is that each office has its own set in stone powers. The Senate knows what those powers are, and when it evaluates whether to confirm someone to a specific office, it's thinking about, are you a good fit for those specific powers? But in effect, take the DOJ, for example, the one I know best. If the attorney general wants someone else other than the head of the Civil Rights Division to start enforcing civil rights law, the attorney general can say, okay, this other person, this other low-ranking person now has all the same powers as the assistant attorney general for civil rights by power of subdelegation. And that, in fact, is exactly what President Clinton did with a fellow named Bill Land Lee, who the Senate had rejected for confirmation to be head of the Civil Rights Division. The Attorney General, Janet Reno, simply subdelegated all the same powers of the Assistant Attorney General for Civil Rights to Bill Land Lee, giving him, another lower-ranking job in the Department of Justice, but with those high-ranking powers. and with no time limit. And that's what really got the Senate's blood boiling, because they thought, okay, if that's legal, then basically the time limits in the Vacancies Act are meaningless. And if the time limits are meaningless, there's no longer an incentive for the president to ever nominate someone permanently. Because if you can have a permanent non-Senate confirmed acting, why go to the trouble of nominating someone? The time limits of the acting office of all the Vacancies Acts were the main stick, the main incentive to get someone confirmed before that time limit runs out. So those were the two key limitations. But to get President Clinton to sign it, they threw him several concessions. They lengthened once again the time limit from 120 days to 210 days. And they added very generous tolling provisions. So once the president makes a nomination, you pause the clock for as long as that nomination's pending. The ball's in the Senate's court. If the Senate rejects it, you get a fresh 210 days for the president to think of someone new to nominate. If he nominates a second person, you pause the clock again. If the Senate rejects that person, you get a final third fresh 210 days. And then finally, the time limit runs out. So if the president actually has his act together and nominates two people, an acting person can serve for more than 4 years under the Vacancies Act, more than a presidential term. And that has, in fact, happened on several occasions. So it's pretty generous. In my opinion, it's too generous. And then in addition, Congress also widened the eligibility options for picking someone. So for centuries, the two categories had been first assistant or Senate confirmed somewhere else. They then added a third category if you've served at the top of the civil service pay scale, which is called the GS 15, is the highest. GS is the name of the pay scale. Goes, I don't know if anyone's at 1, but it goes up to 15. If you're at that top level, you're kind of a high-ranking career civil servant. If you've had such a job for at least 90 days in the same department, you're also eligible to be enacting. So that's the key point there. Is a lot of people in that category have never been confirmed by the Senate to anything, but they were now made potentially eligible to be actings even at the very top of the government, even an acting attorney general, as I'll get into shortly. So that's the state of affairs as it currently stands. Ironically, the goal that Congress had to close this delegation loophole was not successfully achieved. Very quickly, the Office of Legal Counsel, which is another department in the Department of Justice that, in my view, often comes up with creative advice that usually conveniently is in the president's favor when he asks if he can do something and they say yes. They said, the stick I mentioned, the punishment for doing an exclusive duty when you weren't validly appointed, that's actually almost never, the OLC said, almost never going to come into play because of those statutes I mentioned that make everything delegable. They said even if the law only assigns something to X officer, the default rule across the entire executive branch is that all duties are subdelegable to anyone below you unless it explicitly says they're not, unless the statute explicitly says they're not. So silence must be interpreted as subdelegability. And if a power is subdelegable, it's not exclusive, because hypothetically you could have given it to an underling, even if you've never done that or none of your predecessors have ever done that. So the executive branch came up with this theory that basically said only a tiny number of duties across the entire executive branch are exclusive. Therefore, this penalty almost never applies. And courts have pretty much bought that. Most importantly, the D.C. Circuit, which is where the lion's share of Vacancies Act litigation occurs, given that that's where most of these acting officers are stationed in Washington, D.C. They bought that interpretation in a 2004 case, and that's pretty much been what the executive branch has used to get out of this for several years, though there have been a few exceptions. The first one was in a case about William Perry Pendley, who had been rejected by the Senate to be head of the Bureau of Land Management. Basically, the Trump administration used the subdelegation strategy as it's used so many times, but the district court said, no, we're not going to buy it. This seems to go against the whole purpose of the Vacancies Act, so we're going to strike that down. Essentially, the case was mooted out before we got an appeal to the Ninth Circuit, so we never had a precedential ruling on that. And now we have several cases related to acting U.S. attorneys that I'll get into that are raising the same question, and where we may well, for the first time since the D.C. Circuit ruled a while ago, have more circuits weigh in on this important issue. So that's the state of the statutes and kind of the big loopholes, my concerns about the statutory loopholes. But there's also a constitutional question. So I mentioned that, unfortunately, the framers never said what's an inferior officer. And there are two kind of competing approaches to think about it. One might be called the pluralist approach, the multi-factor test, which is you look at a lot of different things and you basically just weigh how important is this office? So the Supreme Court decision that kind of most exemplifies the pluralist approach is Morrison versus Olson from 1988. That was a case about special counsels, predecessors to many of the ones you may have heard of more recently, like Robert Mueller and Jim Comey, essentially people appointed to investigate and potentially prosecute one specific or a few specific government officials. The question was, are they principal or inferior officers? A majority of the Supreme Court, I believe 8 out of 9, say they're inferior officers because of a variety of things. They only have a specific task. Don't have a general ambit. They only have their office up until that task is completed, and then they leave. Even though they were not removable at will, the Supreme Court still said that tenure protection isn't determinative. We're still going to say that on the whole, they're not at the high level. Justice Scalia writes probably his most famous dissent of his career on a host of issues, one of which being, were they inferior officers? Justice Scalia says, no, they were not inferior officers. And he comes up with a more bright line rule. He says, we don't have to look across the board at all sorts of things like their powers or the time that they're going to be in office. We just need to look at one thing. Are they actually supervised and controlled by a superior? So he says inferior was all about hierarchy, having a boss or not. Do you have a superior other than the president? Because his logic ran, and I think this is fairly convincing, the framers only would have felt comfortable with exempting inferior officers from Senate consent if they were confident that every inferior officer has a boss who is confirmed by the Senate. So essentially, one of two things would always be true. If someone does something you don't like in the executive branch, you can either blame your senator who confirmed them, or you can blame your senator who confirmed their boss because their boss could have overruled that inferior officer. And Scalia's point was that as that statute was written, special counsels should not have been considered subordinate or controlled by the attorney general because they had all of these protections. Most importantly, they couldn't be removed at will by the attorney general. They kind of had independence from the attorney general's supervision if the attorney general, even if the attorney general didn't like the direction or the way that they were handling their investigation. So Scalia was in a minority of one in 1988. But things changed by 1995. The Supreme Court has moved much more in his direction, and he writes a majority opinion in another appointments case called Edmund versus United States. And if you read the majority opinion there, it's strikingly similar. It's by Justice Scalia, and it's strikingly similar to how his approach that he preferred in his Morrison versus Olson dissent. So that becomes the new precedential approach to determining if someone is an inferior officer, and it's much more of a bright line rule. Are they sufficiently supervised by a superior? But there's still factors to look at in determining are they supervised. So the three that they look at are day-to-day control. Do you have to check in? Finality of decisions. Can your decisions be overruled? And removability. Can you be removed at will by a superior? So now we get to the issue of acting cabinet members. So in President Trump's first term, there was a lot of turnover in all sorts of cabinet positions, one of which being the attorney general's position. He fires Jeff Sessions at one point because he's mad that Jeff Sessions recused from the appointment of Robert Mueller. And until eventually Bill Barr is nominated and confirmed to succeed him, but there's a gap during which they need an acting attorney general. And the selection is Matthew Whitaker, who had been chief of staff to Jeff Sessions. So he was in that GS-15 category. He was not serving in a Senate-confirmed position in the DOJ. And the question is this constitutional for someone to be serving as an acting officer in a position that undisputably would be principal if it were the permanent person, if it were the Senate confirmed person? So as much as we dispute lots of different offices, whether they're inferior or not inferior, we've come to use principal to just as a shorthand for not inferior, even though that's the word principal officer isn't in the appointments clause itself. There's no doubt that the cabinet members are kind of quintessential principal officers. They have no boss except the president. So clearly, Congress would not have the option to exempt the attorney general from Senate consent if you're talking about the permanent attorney general. So how could it be constitutional for the Vacancies Act to exempt the attorney general position from Senate consent, even in a short-term manner, even for 210 days plus all of those potential extensions that I described? And a lot of people make that argument. But the problem is that there is a really old precedent from 1898, way before Morrison versus Olson, way before Edmund, where the Supreme Court seemed to say that having a time limit is another way that you can be an inferior officer. So it was a very old-timey dispute in lots of different ways. It was about Siam at the time, which is now called Thailand. So if you read that case, there's lots of anachronistic terminology, but in a nutshell, it was about the ambassador, the equivalent of an ambassador who gets really ill, comes back to the U.S. Someone temporarily replaces him who's not Senate confirmed. The Constitution explicitly says ambassadors have to be Senate confirmed. So did this violate the Appointments Clause? And the Supreme Court says no, that if you temporarily give your duties to an inferior, it doesn't make them automatically the principal, so long as it's for a limited time, and so long as it's for a limited time, essentially. So under Eaton, I think it's correct. So long as Eaton is good law, you would have to say that use of the Vacancies Act to appoint acting cabinet members is constitutional. The question is, should Eaton remain good law? Is it compatible with Edmund, that more modern case? And I don't think it is, because Edmund doesn't anywhere talk about time limits to duration as making a difference. It's entirely just about, do you have any boss except the president? And even if it's just for one day, an acting attorney general still has no boss except the president. So the Supreme Court hasn't really grappled with this tension. And indeed, there's tension between Edmund and lots of prior precedents that they still haven't ruled, including, of course, Morrison versus Olson itself. But they've consistently sort of chosen to sidestep this or not dive really deep into those tensions rather than confront it head on and maybe overrule several past precedents. But because of this Eaton precedent, when people challenged Matthew Whitaker and some of the actions he took, appellate courts such as the Fourth Circuit upheld it, saying we're bound by Eaton. We don't have any choice under our system of vertical precedent. So I myself think that Eaton should be overruled, but it's going to require a case directly challenging that and a cert petition directly asking for that before the Supreme Court potentially does that. Now, to tie this in with recent controversies, you all may have followed a lot of the acting U.S. attorney controversies, especially Alina Habba, which really kind of combines all of these issues, all of these Vacancies Act loopholes into one case in a really striking way, and even throws in another wrinkle of the statute specific to U.S. attorneys, acting U.S. attorneys. But just to focus on the Vacancies Act for a bit, there are two key disputes in the Habba case, neither of which the Supreme Court or really most appellate courts have ever resolved. One is eligibility. So I said there are these three categories. You have to be Senate confirmed or a GS-15 or the first assistant to a position to be the acting. Alina Habba wasn't originally any of those. She was outside the government entirely when the Trump administration started. She had become the acting U.S. attorney under the statute specifically for U.S. attorneys, which is a whole separate issue, but she still wasn't a GS-15 or Senate confirmed when she was acting under that other statute. So when her time limit ran out, because that other statute has a shorter 120-day time limit, how did they try to keep her in office under the Vacancies Act? Her time limit ran out. She resigned. The administration fired her first assistant, a woman named Desiree Grace, and then appointed Haba as to replace Grace as the first assistant to the U.S. Attorney Office, which was now completely vacant because her time limit had run out. So she left the office and then became the assistant to the now vacant office. And then, the administration argued, she could instantaneously be elevated back to be the acting U.S. attorney under that first assistant provision. So you might say, wait a second, that seems like a total end run. That if you can do that, why does the first assistant category matter? And it certainly goes against the spirit of the law, because clearly the reason that that's in there is you think that someone who had served as the first assistant under the previous office holder would have some experience. It's like the vice president serving under the president, the next in line. So you obviously don't have any of that experience or qualification if you come in for a millisecond after the office is already vacant and you get bumped up instantaneously. The other issue is that most first assistant positions don't have any statutory limits or qualifications on who can fill them. So it essentially allows you to appoint anyone you want to those, so long as you're willing to fire the old first assistant, as the administration was willing to do here. So this is one of the issues in the Haba case. Is a first assistant appointed after the vacancy happens eligible to be bumped up instantaneously, despite serving for only a millisecond as the first assistant? There are two competing interpretations, and I filed an amicus brief that was actually a middle ground view. So the government, not surprisingly, the Trump administration argues, yes, we can appoint someone after the vacancy happens. The statutory language doesn't explicitly forbid it. It just says the first assistant to the office of such officer can become the acting officer. So in statutory silence means it's allowed. The attorneys for several people who had been prosecuted under Haba, who are trying to throw out their prosecutions, take the opposite view, that no, you had to have been the first assistant way back when the last Senate confirmed person left office, which is way back on January 20th when Trump took office. If you weren't the first assistant way back there, you're not eligible to become an acting officer. That's the position that the district court took. My amicus brief took a middle ground position and said, no, you have to have been the first assistant either under the last Senate confirmed officer or at least under another acting officer. So like Desiree Grace, who was first assistant under Haba when Haba was the acting officer, I argue that if Haba had resigned or her time limit had run out and Grace was left in there, she would have been eligible because she served under another acting officer. But that Haba is still not eligible. On the merits, on the judgment, I come out agreeing with the challengers. I argue Haba was not eligible because she didn't even serve as a first assistant under another acting officer. So that's one issue. And then the other issue is the subdelegation, which is kind of the backup claim that the administration has made. So they're saying, okay, even if you don't buy this first assistant gambit that we did, we also subdelegated all the powers of the U.S. attorney for the District of New Jersey to Haba. So that's our backup view, and that includes the power to prosecute, sign indictments, et cetera. So there's still no concerns. There as well, I think that that's wrong. I think that the statute in the Vacancies Act that explicitly says this is the exclusive means invalidates that strategy, even if they're non-exclusive duties. So I mentioned that provision, the punishment, the enforcement provision has been basically toothless because the administration argues everything's a non-exclusive duty. My position is, even if that's true, the separate provision in the FVRA that says it's the exclusive means of making someone an acting officer, that prevents the executive branch from delegating every single power of a vacant office to one person, which essentially is to make someone an acting officer in all but name. So that's our argument here, and that the district court bought as well. So I agreed with the district court on that, and that's going up, and it's going to be argued in the Third Circuit in Philadelphia a week from today. So we're very much in the middle of these controversies. And just in terms of precedents already on the books, there was one partial win against the first assistant gambit in a case called LMM versus Cuccinelli in the first Trump administration. But that was even more blatant because not only did they appoint someone a first assistant after the vacancy happened, they actually created a new first assistant position purely for the purpose of filling it with Ken Cuccinelli to then make him the acting officer for citizenship and immigration services. So that was the district court in DC said, no, this is a bridge too far. We're not necessarily going to decide about filling a pre-existing first assistant position, but it's just a total legal fiction if you're going to create a position that never actually existed before and wasn't meaningfully created to actually have someone be the first assistant aiding and learning from the person that they're serving under. So these are all the issues going back to appointments. And my big picture point about all of these, it seems it can get very in the weeds. It can get wonky. Why should we care about how long someone serves in office? Is that ultimately we're dealing with the design that the framers made, which was the assumption that people making important decisions should be vetted by the Senate, or at the very least, their bosses with the ability to fire them or change their decisions should be vetted by the Senate. Even in a very compliant Senate that we have now that will confirm almost everybody Trump nominates, even they have lines that they don't cross. If we had no Senate confirmation process, we'd have Attorney General Matt Gaetz right now. And I think it's pretty clear that the Senate probably would not confirm Alina Habba as the U.S. attorney as well. And so we're seeing similar scenario play out now in the Eastern District of Virginia with the prosecution of James Comey and Letitia James, which similarly, it seems no one else in that office was willing to do other than this hand-picked acting U.S. Attorney, Lindsay Halligan. And similarly, we see the problem when the Senate has not vetted someone for that position. Now, to shift over to removals, many of you, I suppose, I understand if you've done 1L con law, you know the basic history of like Myers and those competing cases about removals. Essentially, that is a situation where the Supreme Court is pretty clearly moving much more in a direction of sympathetic toward the president and this idea of a unitary executive. The Constitution obviously doesn't explicitly say what limits can be placed on the president's authority to remove someone. But in general, the Supreme Court, at least in the modern era, has relied on the take care clause as the main justification for the idea that the president should be able to remove at least people at the top of the government. And then in addition, you have cases like Seal of Law that basically say you can't have multiple layers of tenure protection. So we have a case going up to the Supreme Court this term called Slaughter, Trump versus Slaughter, I believe, about Rebecca Slaughter, who Trump attempted to remove from the Federal Trade Commission, which is one of the agencies with statutory for-cause removal protection. And that will most likely raise the question, explicitly one of the questions presented in this case is whether the Supreme Court should formally overrule the precedent Humphrey's executor, the New Deal era precedent that allowed for Congress to create so-called independent agencies where they would have tenure protections and where the president could only remove them for cause. You may have seen that in a so-called shadow docket or emergency docket ruling so far, the Supreme Court has allowed these removals to happen, at least in the interim. And indeed, they explicitly sort of foreshadowed their reasoning by suggesting that these officials exercise significant executive branch authority and therefore need to be removable by the president under the take care clause. So one way you might think about that is that they may not formally overrule Humphrey's executor. They may simply say that circumstances have changed or that our factual understanding of what these independent agencies do has changed. Because when Humphrey's executor was decided in 1935, Supreme Court said, FTC and these other agencies, they're not purely executive power. They're kind of quasi-executive, quasi-judicial, or quasi-executive, quasi-legislative. So if the Supreme Court now says whether that was true or not in 1935, it's no longer true now. They're purely executive, or at least one of their aspects is clearly executive, then they can simply say, under this modern factual understanding, because they exercise at least as much executive power as any cabinet official, they have to be removable at will. A big controversy that's bubbling up now is, what about removals more broadly in the civil service? Does the president have a constitutional authority to fire anyone he wants, all the way down to a post office employee? I don't think anyone would argue that he does. Even Justice Scalia, the most sort of probably the biggest champion for the unitary executive, even in his Morrison versus Olson dissent, he said he doesn't think the president needs unilateral authority to fire inferior officers. He says it's fine to vest that, again, in the principal officer. So just as you sort of have this chain, this logic of you just need someone directly below you that you can remove. This is sort of a similar logic, that if someone is making significant policy decisions, say within the DOJ, you don't necessarily need to have the president be able to fire that person at will, but you do need to have the attorney general be able to fire that person at will. And then if the president doesn't like the attorney general's decisions or lack of decisions, you have the president fire the attorney general. So that may seem somewhat convoluted, but you still sort of have a chain of command. So it's a bit of a stereotype. It's a bit inaccurate that I sometimes see the unitary executive theory described as the president must have the ability to fire everyone in the entire executive branch. I don't think anyone would go that far. And then the question goes, well, how far down does it go? What about I think there's like 3 million employees of the federal government. As you probably know now, they're not doing very much because we're in a shutdown. Is it constitutional to have the tenure protections that we have in the Civil Service Act for those, such that they can only be removed for cause? And I think, again, the main question would be, do they exercise, as the Supreme Court has put it, significant executive authority such that they're officers of the United States? Meaning, do they make policy decisions? If they are, then that means a few things. It means, in terms of their appointments, they needed to be appointed by the attorney general or the cabinet member, him or herself. And then it probably does mean, from a constitutional point of view, that they need to be removable at will, again, by the cabinet member. And so when you see these debates about so-called Schedule F, or I think it's now known by a different name under the second Trump administration, that's essentially an attempt to broaden the definition of who's making significant policy decisions in the executive branch. How many of these people are sort of making decisions that go beyond just the functions of the executive branch, but making decisions that might affect everyday people. And that's, I think, a plausible test for, are you a constitutional officer? Might the Constitution have something to say about it? Now, what the Trump administration is not trying to argue, it's not going straight to the Constitution. It's saying that the civil service law itself allows them to do this and allows them to make them removable at will. But hiding in the background, I'm sure, is a backup argument that makes it that they, I think, would fall back to if it were challenged, and if a court held that no, the civil service laws as written don't allow you to fire these people, or don't allow you to make them removable at will. So another controversy that's happening right now, as we have federal government employees pausing, temporarily furloughed, is, does that, for those who aren't maybe policymakers, does this give more authority for their positions to simply be eliminated than there otherwise would be? And essentially, the way, I'm not as much of an expert on the law of so-called reductions in force, or RIF, but essentially, when the statutory task of a position is eliminated by a change in a statute, under the law, that's one of the justifications that allows you to reduce them in force. So if there's, a statute that says we have to achieve, it's statutorily mandated that we have to run this program, or that we have to have such and such art projects in such and such state, and then Congress repeals that law, understandably, that then gives more flexibility to the executive branch to say, these tasks are no longer statutorily authorized. We're going to have a reduction in force and fire all the people whose tasks are no longer statutorily authorized. The much bolder and I think implausible argument that Russell Vaught at OMB is now making is that when you have a temporary shutdown, when you have a lapse in funding authority, that is essentially at this moment the equivalent of Congress repealing the statutes authorizing the activities of all of the furloughed employees across the board. So even if you're at a perfectly, consistent, even if you're at a position that's going to go right back to being statutorily authorized when Congress inevitably eventually passes a new funding bill, the argument is right now, if Congress has not funded that position, it's the equivalent to Congress repealing the goal of that position. And so in this gap, so long as we're in this temporary gap, you can have a reduction in force and fire all of these people. That to me doesn't seem like the same thing. It seems like quite a stretch. And it also raises a lot of questions about, okay, but what about when we eventually have the funding come back? Do you then have to hire those people back and so on? And even ironically, there's a twist that there's genuine dispute about who may do the paperwork and the logistics of firing people, of carrying out the reduction in force, because in general, those people are in fact furloughed right now, and there are limits on the work that they can do. So it really is a mess to attempt to, get those furloughs, get people to do these actions during the furloughed time. But clearly, this is a part of what the Trump administration is trying to do. I think more broadly, what is the Trump administration's goals? They're pretty obviously making a lot of decisions that have tried to make just things less convenient and less pleasant for civil service employees across the board, across the entire executive branch. A lot of it in hopes that they'll simply quit. And we've seen that. We've seen that in the thousands or probably tens of thousands at this point, whether it's the fork in the road offer or just threatening or in some cases successfully moving offices, such as we saw, for example, the Bureau of Land Management move its office from D.C. to Colorado during Trump's first term and other attempts to move offices outside of D.C. The stated purported justification for this is usually to get it closer to the people, but I think not too hidden. The second justification that the Trump administration likes is that those tenure protected people who they can't explicitly fire will say, I can't uproot my whole family and move across the country. I'm just going to quit and find a new job in D.C. And from the Trump administration's perspective, their view is that the political leanings of the civil service leans left, and that they need to replace them and do any tasks that they can. So what's my view on this? Are we in a constitutional crisis? In terms of removals and acting officers. In terms of removals, I'm not as pessimistic about the downsides of a potential overruling of Humphrey's executor as some are. I think that relying on checks within the executive branch has always been an unsteady state of affairs, an unsteady approach, not the design that the framers originally had in the Constitution. And I think we're seeing that now, that it was always unsteady, and that indeed all we really lacked was a president who was willing to push the bounds of what for-cause removal could mean. We're seeing that now with Lisa Cook on the Federal Reserve Board, Trump arguing that he had cause to fire her over alleged improprieties with mortgage fraud. Whether that's true or not, you're kind of seeing that it was always going to be very hard for courts to hold the line on limiting or preventing presidents from firing the people if they really want to fire them. Similarly, we've had unofficial norms of things like independence within the DOJ, whether that's OLC coming to its own legal conclusions or federal prosecutors deciding not to prosecute someone the president wants to. But what we're seeing now is, again, that was always norms. That was never something that had a firm hold that couldn't be overcome if the president really wanted to by firing everyone else not willing to make the decisions he makes. Does that mean, there's no alternative checks on the president? No. I think it just means, what I hope it means, is that we'll have a revitalization of focus on the checks that are explicitly built into the Constitution, primarily from the other two branches. What we're seeing is particularly judicial review of actions, judicial review of things like Vacancies Act, potential Vacancies Act abuses, or whether it went too far, judicial review of appointments without Senate confirmation, those types of things. Also, of course, jury rights, which is one of the main things we focused on in the executive at Cato, revitalizing jury rights, pushing back against coercive plea bargaining and things like that. And so both grand juries and petite juries serve an important role no matter who the executive branch wants to prosecute. So we're hoping that it revitalizes that a bit. Obviously, Congress as well has been far too AWOL, but in theory, they can also push back against this. They can write statutes that are more specific. With the end of Chevron deference, I think courts are much more likely to interpret laws narrowly when the president claims the authority to take broad, expansive things. I know you've had other sessions or will have sessions on things like the tariffs. I think both the end of Chevron deference and the rise of the major questions doctrine is going to put more power in the judicial branch's court to push back against those actions. So ultimately, I think the executive branch, the way the Constitution was designed, we were always going to get to a point where no one was going to stick around in the executive branch that the president really desperately wanted to get rid of. And ultimately, the executive branch is going to be in the image of the president. And to some extent, I think that actually serves important accountability values. So one example might be the FCC chairman. This is something, since free speech is another of my important issues, I've been following the FCC chairman essentially threatening Disney and ABC, telling them to fire Jimmy Kimmel, saying we can do this the easy way or the hard way. I thought awful. I thought the courts can and should have a role to push back against that. But when you have a agency that's ostensibly independent, unfortunately, the president has a little bit of plausible deniability. In theory, the president can't fire Brendan Carr except without cause. And so if Humphrey's executor, as I expected to, ends, you get rid of that plausible deniability. You can blame, again, a real value within all of these doctrines is blame, accountability. You can blame the president and say, if you didn't like what he's doing, if you don't like the job owning or the coercion that he's acting, you can and should have fired him. And ultimately, and if you don't like what everyone in the executive branch is doing, you can vote against the current president and blame him for the appointments that he made. So with the end of Humphrey's executor, we'll have more direct blame and less ability to evade it by the president. And we'll also have, I think, a focus, an increased focus on the role of the courts and things like pushing back against First Amendment violations, and in the role of Congress in writing laws more narrowly, so that whatever an executive branch official wants to do, their actions just simply won't uphold in court with a judge giving it a fair and unbiased shake. So I'll pause there so we have plenty of time for discussion.
Well, that was really terrific. Thank you so much for that. We're going to turn now to our seminar with the students. So for those of you watching online, thank you and see you next week.